right, we're going to go ahead and get started. This is this quarter's chapter of our interactive dialogue series featuring IP topics from Dorsey and Whitney. This morning, my name is Jennifer Spaith, and I'm a partner in our patent group here at Dorsey. This morning, I have my colleague Ron Moscona, a partner of mine in our London office, and our topic is IP in Europe after Brexit. We're going to talk about registrations, enforcement, and other questions, and generally what the climate looks like it will be and how the Brexit issue may affect intellectual property topics moving forward. As I say, this morning I'm joined on the phone by Ron Moscona, a partner of mine in our London office. Ron advises on a wide range of technology-related transactions, investments, and compliance matters, and works frequently with clients in the software and digital fields, electronics and telecom, medical devices, and life sciences industries. So good morning, Ron.
Hi, everyone. Thanks for the introduction, Jennifer. Good morning to those of you in the West, I guess. And I'm hoping that that this should be an interesting topic for everyone, those in the UK and Europe, and those in the US. So I guess we can start by talking about how we get to this topic. And
I'll just touch on a little bit of logistics. Certainly, if you have questions during the presentation, please feel free to enter those into the chat box in your screen, and I'll see those, and I'll try to work those into our discussion as we go along. We try to have this be a conversational format, sort of between Ron and myself, similar to the way we would be advising a client or speak, based on things that we've been speaking with folks about from time to time and issues that we've seen come up. So we do try to make it conversational. If you've got questions, type those into the question box and I'll work those into the conversation. After about 40 minutes, I will announce the New York CLE code. We do have some New York lawyers participating today. So I'll read that code out about for a little bit after 40 minutes into our conversation. So with that, let's talk a little, Ron, about how we arrived at this topic. Brexit, particularly here in the U.S., was a huge news story and closely followed and caused a lot of concern and a little bit of chaos in the days immediately after the vote. And so maybe set the stage for us now as to what things are like and how this topic is going to be meaningful.
All right, so as everyone knows, earlier in the year, the UK government and the Parliament decided to put the UK's membership in the EU and the European Union to a referendum, and against all expectations, the referendum results were to leave the EU. Now, this came as quite a shock, I think, for the UK and for Europe, and a great surprise to much of the world. From a business point of view, I think a lot of companies over the years and practitioners have become accustomed to thinking of Europe as one market and one destination, and got used to the idea that local differences between member states, which of course exist even in America between states, are marginal, and the big issues are probably can be dealt with at the general EU level. And all of a sudden we've got Brexit. Now I think perhaps people outside of Europe and outside of the UK may not appreciate to what extent what Brexit actually means is very much a matter open to debate and future negotiations. And my personal belief is that it's going to be many, many years before we actually see something shaping up, even though over the next 2 years a certain picture might arise. The fact of the matter is that today, even within the UK government, there seems to be no consensus as to what Brexit should mean and what the relationship between the UK and the rest of the EU should look like. once the UK leaves the EU. One thing to remember, and of course to bear in mind, is that the UK is still very much part of the EU, and Brexit will not happen for probably at least 2 years from next March, which is the next March is have been suggested in the last few days as the date in which Britain might give notice to the EU that it's leaving, but that notice takes effect only after 2 years, which is supposed to provide some time for the parties to negotiate alternative arrangements. The common view is that in reality negotiating alternative arrangements might take 7 or 8 years rather than 2 years, so we don't actually know what's going to happen. Now, the UK is a large economy, perhaps the 5th or 6th largest in the world, and because of its relaxed regulatory environment, English language, low level of bureaucracy and so forth, it has been and still is considered the gateway into Europe for many international businesses, and also very often, and also because of tax benefits, some companies or many companies place its European headquarters in the UK. So for a lot of these international businesses, it matters a lot what kind of relationship the UK is going to have with Europe in the meaning, and what actually Brexit actually is going to mean for them. In the context of IP, well, IP is a large part of what the European is all about. IP rights are highly integrated across the EU. And you can see the same thing really if you think about the US, where a lot of things are organized at the state level. IP is one of those areas where actually mostly it's federal, or most of what matters is federal. The patents, the trademarks, the copyright, these are federal arrangements and not by chance. And in the same way in Europe, in order to create a single market, in order to create a unified kind of economic entity, IP exists both at the local level and at the European level, but it's highly integrated at the European level with a lot of European rights and harmonization across Europe, and a number of other things that I will talk about in this presentation today. So again, how Brexit is going to impact these IP structures is a big question, and to some extent, or to a very large extent, we don't actually know what it's going to look like in the future.
And I just want to underscore the timing, Ron. So you're saying it's now March is being the largely rumored date at which notice will be given, and from then it would be at least 2 years, but you're saying possibly longer before there would be any certainty. Is that generally?
Yes, I mean, I think it'll be much longer before there's certainty. The way the treaty is structured is that there's a 2-year period for a leaving country to negotiate its way out. At the end of that 2-year period, there could be a guillotine, so the UK could overnight cease to become a member of the EU. But the parties, that is, if there's consensus across all of the EU and the UK to continue membership for a little bit longer, that's also a possibility. So the notice does trigger a 2-year period, at the end of which, in the absence of another agreement, the UK will be out of the EU. Of course, probably the most likely scenario is that at the end of these 2 years, we will have some kind of transitional arrangement, and there could be kind of transitional trade arrangements or transitional institutional arrangements by which certain of the EU institutions will continue to apply to the UK. But actually, we don't know. We can only speculate. One thing we do know is that the whole issue is highly complex, and I think this discussion today will give a few examples of the complexities of these issues. And it's not that easy for a country to leave the EU. I mean, just imagine what would happen if New York State decided to leave the US. I mean, just the legal complexities and regulatory complexities and everything is difficult to fathom. And that's why I think that whatever happens, whatever clarity we're going to have over the next 2.5 years, even after that, there's going to be a lot of movement and changes and fudges. And I think it'll take many, many years for the actual trade relationship and legal relationships between the UK and the EU to stabilize.
Right. And so then in terms of IP, as you mentioned, with most of those systems being what we would consider federal, I know you've got a list here of things that we're going to touch on today, but it really does seem to cut across most important categories of IP.
Yes, and there's a different story for each of them. So we'll go through 3 or 4 slides to talk about patents first, specifically about pharmaceuticals and medical devices, which are kind of a particularly important category within IP and within patents. And then we'll talk briefly about the EU trademarks and EU designs, which are equivalent to the federal trademarks and federal design patents in the US. Then we'll talk about copyright. So there's a different story for each of these categories of IP rights. And then there's 2 general issues which I hope we'll get to, and one of them is about enforcement and jurisdiction across the EU, and the next is about exhaustion of IP rights, which has to do with trade particularly trade of goods across the EU.
Yeah, I hope we get to that one too, because I think it's interesting. But let's turn to patents. I know I, for one, am regretting the time I invested in understanding what the unitary patent was going to look like.
Yes, indeed. I mean, we all have spent a lot of effort on that over the last 2 years. It's difficult to gauge the level of knowledge of the audience in the European patent system, but I'll just very quickly canter through it. In Europe, there are national patents, like in every other country in the world. There are European patents, which is a kind of a strange category, because European patents are granted by the European Patent Office, but then they're validated on a national basis. So they start their life a little bit like the PCT system. They start their lives as a single patent application and even a single granted patent, but then they live their lives as granted patents at the national level. And then we have what we call the unitary patent, which was created in theory 2 years ago by European legislation, and the system of a unified patent court, which is in the course of being established across Europe. Now, these systems, for those who learned about them, they're not in place yet. The unitary patent was supposed to be, or is supposed to be, a single patent for the European Union in a similar way, or in the same way, really, that the American federal patent is a single patent for all of the US. As I say, the current European patent system doesn't provide for that, and in fact, the European Patent Convention is not an EU convention. It's actually wider than the EU, and it will not be affected by Brexit. So one thing to know, that in fact the current patent system as it exists today, with national patents, European patents granted by the European Patent Office in Munich, and the national validation and the use of the PCT system to register European and national patents in Europe, none of that is going to change at all, because none of that is an EU creation. It's not part of the EU institutions. What is going to be highly affected is the recent agreements about the unitary patent, or the European patent with unitary effects, to use the full terminology, and the unified patent court. Now that was a dream, really, that was in the planning for more than 40 years. I mean, they started talking about that unified patent for Europe since 1969. More or less when the European Patent Convention was put in place. But because of a lot of practical difficulties, not least issues of languages, it took, as I say, 40 years and a good 10 years of extensive negotiations during the since the year 2000 or the year 99 or something like that, to get Europe into agreement. Even then, as many of you might remember, 3 countries opted out or partially opted out from that system. So Spain, Italy, and Poland, where Spain opted out from both unitary patent and the unified patent court, Italy from one of them, and Poland from one of them. So it was kind of imperfect in the first place. But now with Brexit, there's a huge question, and there are 2 big questions. One big question is whether this system will ever become reality, and the second is, if this system ever becomes reality, could it be possible that the UK would be part of it? And I think the answers are probably no for the first one, but maybe, and most likely no for the second one. So to give just a little bit of details, the unified unitary patent legislation and the Unified Patent Court arrangements are all subject to ratification by 13 member states, 3 of which have to be the UK, France, and Germany. The UK hasn't yet ratified the agreement, not because it didn't want to be part of it, but I guess it didn't want to jump in, and maybe the government had the referendum in mind and didn't ratify for that reason. The truth is that very few countries ratified it, but the expectation was that in the next in the absence of Brexit, in the next few months, most of the countries would ratify it. Now, it is an international agreement that will not come into force unless the UK ratifies it, and the UK is not going to ratify it because it just decided on Brexit. So first and foremost, this system is, the brakes have been put down on this system, and it's not going to happen anytime soon. It can only happen if there's any element of renegotiation between the parties. So the two scenarios that are possible is that either the rest of the EU member states decide to come together and agree on a unified patent system and a unitary patent court, which will not include the UK. Now, this would be
the existing legislation to do that has taken 40 years. I mean, right?
Yeah, and it was and the balances, and one of the difficulties is that one of the problems, and the main problems that this system faced is that of languages. Languages are important for patents, and the European Patent Office works in 3 languages: English, German, and French. And of course, if Britain is not part of that system, then the other large countries, mainly Spain and Italy, both countries either opted out or partially opted out from the original system, would be unhappy for that system to continue on the basis of these 3 languages, English becoming a negligible language in the EU. And language is not the only thing. The other thing is institutions. So the Unitary Patent Court was going to be focused very, very largely on 3 countries, Germany, France, and England. And the reason is that certainly Germany and England, Germany and the UK, are the main patent jurisdictions where, in all respects, where most patentees come from, where most companies that take patents come from, where most practitioners work, where most expertise exists, and by far the most patent litigation happens. So taking the UK out of this equation creates a system in which there's only one really large patent jurisdiction, which is Germany, another large country which has its kind of foot in the door, France, and then a lot of other countries which have really only a limited patent interest, and that in itself is probably a reason why it's unlikely for that system to rise like a phoenix, because they just wouldn't find the right balance without the UK being part of that system. Now, the UK itself is contrary to what a lot of people have said, and there's been a lot of talk about this issue in the last few months. The way it looks, at least at the moment, it's very unlikely that the UK would participate in the system in the future, because it assumes very much as one of its founding principles that the supremacy of EU law and the supremacy of the European Court of Justice, or the Court of Justice of the European Union, and this is one of the, at least politically and for political people, one of the main reasons for the UK to leave the EU is the desire for sovereignty and unhappiness about being subject to the jurisdiction of the Court of Justice of the EU. So it's highly unlikely that in Brexit negotiations the UK would wish to go back into a system in which its patent system is basically subservient or subject to the decisions of a European court. That would be quite contrary to the idea of Brexit as it is perceived within the UK. In addition, the other side of the coin is that from the point of view of the remaining European countries, participation in the EU generally and participation in institutions such as the unitary patent and the unified patent court is a great privilege, which is not offered to countries which don't want to be part of the EU. So I don't think there's any serious likelihood that the other European member states would offer a special arrangement for Britain to be part of this system, because that would be perceived as one of many other kind of prizes that are given to a country that doesn't want to participate. So, all of the political currents seem to go against the UK ever participating in a system like that. I think the likelihood is very, very low at the moment, unless we end up with what is called a very, very soft Brexit, in which the UK is effectively almost part of the EU, or part of the EU in everything but name, which is still possible, of course, and a lot of people would want that outcome, but the way things look at the moment, it seems a bit unlikely. Unless we end up with a very soft Brexit, then it's unlikely that the UK would ever participate in a unitary patent system for Europe, and I think practically and politically it would be pretty hard for the rest of the European countries to resurrect that system between them. And on top of that, it's and it has been said that there's serious doubts whether that system would be any good, because you would end up with a kind of two big competing systems. One, the UK system, which is a big patent system with a lot of patent litigation, a lot of pharmaceutical companies and other patent companies based here and selling a lot here, competing against another big system in Europe. And that kind of, the whole idea of a unitary system was to avoid these competitions between jurisdictions. So it's unclear whether it would serve any point actually to have that system without the UK.
And so the European system that currently exists with the European Patent Office is unaffected, but we're not likely to see the sweeping unitary patent and the parallel unitary courts that some of us have invested a fair amount of time in understanding.
Yes, exactly. And I think a great hope within Europe to add to the European puzzle and an important element to help make Europe into a single market. Because I think the whole story of Europe is about trying to make something which is genuinely a single market, and adding that unitary patent and unified patent court would certainly, from a business and technology point of view, is a great addition, and sadly that would not happen as it looks at the moment.
Yeah, let's talk. I know you added some thoughts about pharma and med devices. We have a fair number of pharmaceutical and medical device company representatives on the line, so we wanted to address some of those regulatory and other issues as well.
Yes, I mean that takes us a little bit outside of the strict IP area, but one legal point to mention is that the supplementary protection certificates, which is the European equivalent to the patent extension system that exists in many parts of the world, and also the data exclusivity under both of these are legal institutions, if you like, that exist under EU law. They've been created late in the day when everything was already kind of in the hands of the EU. They don't exist in domestic UK law. So the supplementary protection certificate is the extension of patents for pharmaceutical devices pharmaceutical products which are subject to regulatory approval for up to 5 years, depending on the length of the delay between patent filing and obtaining a regulatory approval for the product. Data exclusivity is simply the 10-year data exclusivity that relate to clinical trials that the pharmaceutical company gets upon first approval. So these things exist under EU law at the moment, and the supplementary protection certificate relates to the date of the first marketing authorization in the EU. Now, it is more than likely, it's almost certain that the UK, with a very strong pharmaceutical sector, will adopt a similar domestic legislation, or at least a domestic legislation to provide for an extension of patent protection for pharmaceutical products. I mean, since these systems started in the, I think, late 80s in the US, they have been adopted across the industrial world, and it's highly likely that the UK would want to have that system as well in order to encourage research into pharmaceutical development in the UK. It's just not going to be part of the EU system. Now, the existing system is highly linked to the highly developed European regulatory regime for approving pharmaceutical products and medical devices. Now, this is a good example, I think, of how Brexit will actually affect reality, because at the moment the European system is not quite as in the US. There's no single FDA, but there is the EMA, the European Medicines Agency, which functions pretty much like the FDA and which can grant marketing authorizations, the equivalent of approvals for the marketing of pharmaceutical products across the EU. And in addition to that, there's the non-centralized procedures whereby marketing authorizations can be obtained on a country-by-country basis, but it's not really entirely market by market, because there's a huge level of reciprocity and cooperation between regulatory institutions in Europe. Now, one of the interesting things about this is that the UK regulator, the MHRA, is one of the most powerful pharmaceutical regulators in Europe, and one of the most influential. And in the system of cooperation between regulators and all of that, it plays a huge role. The European Medicines Agency itself sits in London, so the whole European regulatory system for pharmaceuticals, and to some extent also medical devices, is focused quite a lot on the UK. And this is where there is a lot of the expertise. Of course, there's quite a significant amount of expertise in other countries, particularly in Germany, perhaps in France, but the UK is a major part of that. Now, it is possible, maybe more than in other areas, that a level of cooperation will continue to exist across or between the UK and the rest of the EU, or the remaining EU, in relation to pharmaceutical regulation and marketing authorizations in the future post-Brexit. I think in a scenario of soft Brexit, it's highly likely that the current system will continue as it is. It is less sensitive to things like the jurisdiction of the European Court of Justice. It's a regulatory system, not so much a legal system such as patents. And it is possible that at least a high level of cooperation, of regulatory cooperation, will continue to exist in the future. And it is possible that supplementary protection certificates will continue to be linked to the European regulatory system. But if not, then a similar system will probably be devised in the UK. But how pharmaceutical regulation is going to continue after Brexit is a very interesting and completely unknown question for the future.
Yeah, and so you mentioned the MHRA being one of the important parts of that system, and if that becomes, truly meaningfully separate from the EU, is the thought that the EU would have to beef up their own experience and knowledge and role in that for the remaining EU markets?
Yeah, I think the reality is that it's not that these are primitive markets. They do have knowledge and experience, certainly in Germany. But again, if you're taking out the country that has the most expertise and the greatest influence on the regulatory regime in pharmaceuticals, then you have a problem. And it's not the kind of thing that you can create overnight. It takes many years, and I think the Europeans in this particular area will have a genuine interest to try to keep a close collaboration with the UK. Of course, some people would eye, the opportunity to host, to be the new home of the European Medicines Agency. So there would be kind of professional interest for, Germans or French or others to take over that role and that prestige. But on the other hand, in order to keep a high quality system going forward, they might want to keep a close level of cooperation with the UK system and the UK industry. I mean, it's an industry issue, isn't it?
Right. So let's maybe turn back to traditional IP categories and discuss what will happen with the trademark system. We've also had a question, which maybe is actually good to sort of insert at this point, about what happens with existing rights, both patents, CE marking procedures, and then here it's germane also with the trademarks. Do those rights persist after a Brexit activity, or will they need to be resubmitted or re-perfected in some way after the UK is not part of Europe? I mean, certainly I'll venture the guess that the patent answer being that the European patent system is, we've talked about sort of the existing system being unaffected by this, and so any UK validations still being unaffected in terms of the patents, but in terms of other regulatory or trademark issues, the answer may be a bit different.
Yes, that's right. So the patents, luckily, I guess, the luck here is that the European Patent Convention is not an EU institution, and the system will carry on unaffected. So in the area of patents, the only effect is on the future that would have been the unitary system that never actually came into being. So existing patents would not have to be refiled. Existing regulatory approvals, I think that is a big issue. I think there would have to be some level of evergreening or grandfathering, whatever is the right term. It would be very, very surprising if there would be any situation where a product on the market would have to be refiled for regulatory approval after Brexit. I mean, I think it's too much to consider. I think there would be definitely an element of respecting existing approvals, and there would be a different question, of course, what would be the value of a CE marking in the UK post-Brexit. But I think for products that acquired the CE marking or the marketing authorization before Brexit, I think it's highly unlikely that the UK would require refiling. It would disrupt existing commercial markets. It would create a huge regulatory burden on the UK system, and there's lots of reasons why it's unlikely this should happen. The same picture is probably going to be in relation to trademarks and designs. Now, in this area, although we don't know what's going to happen, the future arrangements post-Brexit are I think, fairly easy to predict, because it's not that complicated, really. And we do have precedents. We have precedents not of countries leaving the EU, but we have precedents of the EU expanding into new territories. And about 10, 15 years ago, the EU expanded a lot to the east, mainly. And in two words, what happened at that point is that what used to be called community trademarks, and that was before community designs were created, but community trademarks, which are today called EU trademarks, were automatically extended to the new territories, subject to existing prior rights. So in whenever it was 2003, if you had a community trademark for your mark for Kodak or Coca-Cola or something, overnight that community trademark became enforceable in Poland and the Czech Republic and the rest of Eastern Europe. the only proviso was that it was qualify. It was subject to any rights that existed locally, conflicting rights at the date of expansion. So I think what will happen upon Brexit is fairly simple. That any community or EU trademarks and EU designs that were registered before Brexit date will be respected as national rights in the UK post-Brexit, and that makes a lot of sense, because otherwise you'd be depriving people from property that they acquired. I mean, if you have a EU trademark or EU design today, it is under UK legislation protected in the UK as if it is a UK registered right. And it's unlikely that Brexit will interfere with those vested rights. Of course, there is a possibility that there will be some kind of administrative burden to perhaps not refile, but give notice that you want your community trademark to continue as a UK trademark or design. It is possible. I think the only reason to propose something like that would be to generate some fees, or to clean up the register from rights which are not really used or necessary. I mean, that could be a logical reason. So if people don't really need those rights or don't need them in the UK, they won't be unnecessarily treated as registered. So there are some logical reasons why to expect some kind of administrative requirement. But I think the burden of dealing with these administrative kind of steps would be a good reason for the UK to waive any such requirements, or not to impose them, and simply to declare in its own law that any rights that have existed or granted until the date of Brexit will continue to be enforced in the UK as if they were granted in the UK. Now, from going a little bit to a lower level of detail, then of course, once Brexit happens, the UK is not going to be subject to the jurisdiction of the European Trademark and Design or the European Intellectual Property Office, nor to the jurisdiction of the European Court. So if post-Brexit a community design or a European trademark is invalidated by a court in Europe or by the European IPO, then it's likely that this decision will not affect the protection of the right in the UK. It's almost certain, because the whole point of Brexit is to not to be subject to jurisdiction of European institutions and courts. So I think, again, I'm predicting the future and I'm guessing, but it's highly likely that what will happen is that these rights will overnight be deemed to be independent UK rights and no longer affected by what happens to them at the European level. Now, of course, for any future rights, there will have to be new filings. I mean, post-Brexit, it's obvious that if you want to acquire UK protection for your trademark, you have to register it in the UK. Again, unless we're talking about a very, very soft kind of Brexit where European trademarks are enforceable, continuingly to be enforceable in the UK, but this is highly unlikely. That's not even the case for the members of the European Economic Area. Norway, for example, community trademarks and designs do not extend to Norway, even though Norway is as close to the EU as can be. So it's quite clear that for new rights, one would have to file separately in the UK. And it is likely that in relation to any applications which are pending before the EU IPO office on the Brexit date, one would be able to extend that application probably with the same priority date to the UK, but it'll have to be examined by the UK office if it hadn't been granted by the date of Brexit. Again, I'm guessing here, but it's quite likely that would be the case, because the UK wouldn't want in principle to be subject to examiner decisions made in Alicante, the home of the EU Intellectual Property Office, if the decision is made after the Brexit date. So, of course, there's going to be other complications in terms of territories of use and so forth, but in principle, the separation of the UK from the EU system is not going to be too complicated when it comes to EU trademarks and designs.
Yeah, and So we've had another question as well, which I think, now kind of reading tea leaves, and you've talked about kind of what happens and what's likely to happen and what might be different if it was sort of, as you put it, a soft Brexit. And so, looking at those kinds of issues, and particularly with then different court systems, what is the likelihood of some amount of reciprocity as between the UK and the EU as to regulatory decisions, or in this case, invalidation of these trademark rights? How likely is it that there would be some amount of reciprocity as between the EU and the UK as to those types of decisions?
Yeah, I think. I mean, obviously we don't know, but I think at the regulatory level, it's quite likely that there would be a high level of reciprocity, because it's for everyone's benefit. It's a very professional system. It's at the level of CE marking, for example. I mean, one of the things that I think the EU did quite well is developing EU standards for safety and so forth. And I think the UK would have no problem continuing to adhere to these standards. And also, it doesn't harm anyone's interest that the UK would continue to apply the same standards as the EU, which would make investment easier. It would in itself remove trade barriers between the UK and the EU, and it doesn't involve any concessions on sovereignty or independence. So when it comes to regulatory cooperation and mutual recognition, I think there's going to be a lot of that in the future. I think even today there is at least a level of respect between regulators across the world, and between the European regulatory authorities and the US, for example. There's of course they can take different decisions on different issues, but there is also a level of respect and I think there's a level of cooperation in terms of clinical trials, in terms of all sorts of regulatory issues like standards and so forth. So I think it's likely that this will continue to some level in the future. When it comes to decisions on validity of patents and trademarks, I don't think there's going to be much reciprocity in the future. Going on to the issue of copyright, again, it's a different story with copyright. Copyright is not a registered right, certainly not in Europe. I know that there are registrations in the US, but not even there. It's not a right that exists by reason of the registration. In Europe, it's an unregistered right. It exists only under national law. There's no real European copyright. However, on the other hand, copyright laws in Europe have been extensively harmonized, and there's a great deal of harmonizing legislation, and it came with various pieces of legislation that are mentioned. I mean, some of them are mentioned in the slide, and they tended to go industry by industry, from software to satellite and broadcasting and so forth. And the European Court of Justice has been increasingly very vocal in terms of pushing copyright issues, and recently, very recently, only a few days ago, really, the European Commission at last, and that's been on the stocks for a long time, it came up with a new proposed directive for copyright in the digital single market. So the issues that are being tackled there is all of the copyright issues and other issues that are thrown up by the digital environment, and so there's a proposal for new legislation there. Very recently, I'm sure some of you may have heard about the European decision in the Playboy case that came from the Netherlands about links in websites, and where it was decided, I think quite controversially, I would say, that providing a link on your website could itself be an infringement of copyright if the link leads to an infringing content on a third-party website. So that is an example where European harmonization is kind of pushing the envelope quite a lot in the European Court of Justice on the basis of general provisions in European legislation about, in this case, the right for the exclusive right to authorize communication to the public. By interpreting legislation like that, the European Court takes its own view as to the right balance, if you like, between the interests of the right holders, the copyright industry, and so forth, and the interests of free speech and free movement of information. And in this case, these are the kind of decisions that impact the whole of the EU. So what Brexit is going to mean for copyright is that, quite simply, the UK will be able to have its own mind as to where copyright should go. It won't be subject any longer to harmonizing legislation. The law is not going to change overnight, but the UK will be fully independent in applying its copyright laws and in changing them and in introducing new ideas or different ideas from those that are developed in Europe. So it's not going to affect the interests of businesses in any real way. It's just going to mean that it's going to be a more independent jurisdiction.
But it sounds like, given some of the sort of boundary-pushing cases, as you've pointed out, that the EU has taken, it's quite possible that the UK would take a different view of some of those issues and take its copyright law in a slightly different direction.
Yes, absolutely, and I think it's not just the legislation. I mean, legislation is very slow in changing copyright law because, unlike other areas, I think copyright law is heavily influenced by industry pressure, and in the last few years it was very much the copyright industries on the one hand, and the media and digital kind of lobby on the other hand. So Google has been lobbying heavily in Europe in relation to digital matters, and also Facebook and others as potential infringers or potential defendants to infringement claims. And of course the Hollywood and the music industry and all of that are pushing from the other side. So every legislation is the result of a lot of lobbying and pressure, and I think UK courts will very soon start disregarding the precedents of the European courts and taking their own view.
Yeah, well, I'm excited that we have a decent amount of time here left to talk about enforcement and some trade issues that we've put in here, because I think some of these types of issues get overlooked a little bit, and may very well be some of the most significant things that come out of the Brexit vote in terms of, in practice, what actually changes. So let's look a little bit about enforceability of judgments and how things are going to get enforced, once
Yes.
there's no EU.
Indeed, and I think, I regret a bit, these are not the kind of issues that are easy to explain, but I think they are going to have a much wider and significant impact on day-to-day life, and enforcement of IP across the EU is definitely an example, because one of the kind of results, or even unintentional results of the Brexit decision, is that the UK will find itself outside of some very grey, very boring, not very famous perhaps pieces of legislation in the EU that regulate very, very important things like jurisdiction and enforcement of judgments across borders. The lawyers amongst us certainly will appreciate how important these things are in practice, and Europe actually has a great system. Of course, this kind of thing is not the kind of thing why voters or politicians decide to enter or leave the EU, but it's actually very important. So the EU has a mature and developed system for both choice of law, jurisdiction, enforcement of judgments across countries. So if it comes to enforcement, that is the kind of most important thing, because the EU, in terms of enforcement of judgment, is pretty much like a national state. Just like you can, I think, I don't know, but I imagine that it's easy enough to enforce the judgment of a new court in California. It might be even easier to enforce a German or a decision of a German court in Spain. There's automatic enforcement. It doesn't require any proceedings. It is designed for to function as if you are within the same country, and that will get lost, of course, between the UK and the EU once we are out. The Brussels regulation again is a something that started as a convention from 1969 and became a EU legislation over the years. That is a piece of legislation that deals with all of the issues of conflicts between jurisdictions, and it organizes the system in a very nice and neat way so that it actually minimizes the issues of forum shopping and contests between jurisdictions in Europe, not just for IP but generally. I'm not saying that these things don't exist at all. Of course, there's always a level at which there will be some contest or some forum shopping, but the regulation has largely eliminated that. And sadly, there seems to be no legal way in which the UK could continue to be part of that system unless all of the EU member states will agree to sign a new treaty with the UK which implements the same principles. I don't think there should be any really good reason not to do that, but it would require a lot of political goodwill, and it does require consensus. And trying to get consensus from 28 independent states is not easy, particularly when there's always one or two that might have their own agenda.
Sure.
So, so what will happen is that the UK will find itself outside of that system, and the result will be a much grittier kind of system of both uncertainty in terms of where to sue and where you can sue, and whether if you sue in one place, your judgment is going to be enforced in another case. And of course, the issues with IP, what do you do when there's a German company that is infringing your UK patent, for example? Do you sue them in the UK or do you sue them in Germany? And if you sue them in the UK, what does that mean? And if you sue them in Germany and so forth. So at the moment, the position is fairly clear. The law has been developed and clarified through sensible judgments over the years, and the legislation is pretty clear. So we have a neat system which works quite smoothly, and unless by some miracle the UK can kind of join that system post-Brexit, then we will have a less neat system in the future, where there'll be probably more litigation costs over both choice of jurisdiction, as I say, contests between jurisdictions, conflicting judgments on the same case in different countries, and difficulties in enforcement.
But with that, let's turn to Ron to exhaustion of IP rights and trade, and the trade implications of this, and really thinking through what the EU was, is really intended to be as a free trade grouping, and what that means for the UK leaving that, I thought was very interesting to consider.
Yes, yeah. Well, I mean, the EU is of course first and foremost not just a free trade grouping, but a single market and a single customs territory, which means a lot. It means not only that there's no customs or other procedures as between member states, and that goods, services, people, and capital are supposed to flow freely through numerous forms of legislation and arrangements. It also means that if you bring goods into the EU, it doesn't matter where where you bring them to, you will pay the same tariffs, will apply the same rates, and it functions as a single market for all trade purposes. Also, as it happens when it comes to sanctions and export controls and all of that, these two are almost entirely governed by EU-wide arrangements. So, and of course, at least from the economic point of view, and not just the economic point of view, even beyond that, that is the heart of the EU. It is the idea of making this collection of, at the moment, 28 independent states into a single economic and even cultural and to some extent political system. So what Brexit is going to mean in that respect is the number one question that everyone is asking, and the big argument, at least over the summer, I don't know if it has been settled or not, is whether the UK is at least going to try to stay within the single market. In a way, obviously, if the UK stays in the single market, then it stays within. It's a very soft Brexit kind of scenario, and it means that although the UK might not be officially part of the EU, it would for a lot of practical purposes it will be part of the EU. If it's not part of the single market, then it's a different story. There might be free trade arrangements between the UK and the EU, but that's far less than being in a single customs union, or in a single market generally, and things like regulatory approvals and regimes and things like that obviously form part of that system. IP also forms a very important part of that system in a number of ways, and we only have about 4 minutes, so I'll trot through that very quickly. But the principle is that IP rights cannot be used to stop trade of goods between member states. So that is the principle of exhaustion. Once you've sold a stock of goods in Germany, they can be resold freely across the EU. Also, in terms of EU competition rules, if you sell products to your German distributor, you can't stop that German distributor from selling products to a Swedish customer or distributor. You can place certain restrictions, but generally you can't, as a matter of EU competition law, to break down the markets in that way. That means that is very significant for patent and trademark owners, because they cannot use their rights to segregate markets. Now, whether or not post-Brexit patents and trademarks will be potentially used to break or to carve markets, or to carve a firm line between the UK and Europe in terms of the marketing of goods, is to be seen. We really don't know, and I wouldn't venture even to guess what is going to happen and what sort of arrangements will be in place. On the other hand, the last bullet point refers to the Silhouette decision, the decision of 20 years ago, in which the EU court decided that the principles of exhaustion of rights within the EU mean that countries cannot apply a rule of international exhaustion, which means that a country is not free to say if something was, if a stock of jeans were put on the market by Levi's in the US, they can be freely brought under the mark into your country. That is a principle of international exhaustion. The idea behind which is to say if Levi's decide to sell its products, say in Singapore, then everyone is free to sell them under that mark in the UK. So the EU decided, or the EU court decided against that principle, and as a result of that, it creates Europe as a kind of a fortress Europe, as it's sometimes called, a region in which the trademark and other IP owners can control the entry of products into the customs union through their trademarks. Now, post-Brexit, it's quite possible that the UK will reintroduce its own approach to international exhaustion, and that would create a complicated system within Europe. So we'll see. I mean, but it is going to be a big issue.
Well, great. Thanks, Ron, and thanks to everyone for their participation this morning. Logistics-wise, if you are looking for CLE credit for your attendance at this program, you will want to complete the sign-in sheet that was included in the reminder email that should have been sent to you yesterday, and return it to Michelle Hubble, which was also indicated in that email, or her address is on the screen right now, and then Dorsey will have CLE certificates sent to those who have returned the form. So if you're looking for CLE credit, please do complete that form. Ron's contact information is on this slide should you want to reach out with additional questions. I know a lot of the issues that we were talking about are complex and specific to certain industries, so certainly feel free to reach out to Ron with any additional questions or follow-ups that you might have. I also like to plug the next chapter of our IP Interactive Dialogue series, and in January we'll be talking about subject matter eligibility in the patent world, and we'll be looking at how to craft your patent strategy and also your licensing strategy now that there's been a significant change in patent subject matter eligibility applicable to both the software and medical industries. So we'll be looking at that in January, and I hope that many of you would be interested to join that as well. So thank you again for all of your attendance today, and there again is Ron's contact information for follow-up. Thank you.
Thank you very much, everyone. Goodbye.